We attended court this morning and we inquired as to whether the court would have a common law jurisdiction. It is our lawful understanding that as soon as we cross the threshold it would move into maritime law, which is the law of the sea, not the law of the land. We questioned this on 3 occasions, no less, and the judge in action, David Robinson, called security upon us. Further to this, in the original defence reply to the defence statement from Middlesbrough Borough Council and its agent Andrew Richard Perryman, they have committed crimes against the defendant. Okay, Andrew Richard Perryman, in his capacity as head of legal services as an officer of the court in his role as a solicitor, has submitted in his reply to the defence statement a false written statement with a signed statement of truth dated 14th of December 2022 in judicial proceedings that clearly evidences the crimes of sedition, malfeasance in public office, perjury and perverting the course of justice to the monumental detriment of Mr Lateef, and further to this, threatening the peace, happiness and security of our noble King Charles III and the subjects of the King through his evidence contempt of the sovereign, contempt of statute. In a reply to the defence statement submitted by Andrew Richard Perryman with a signed statement of truth dated 14th of December 2022, it is falsely stated in paragraph 2 of this evidence, irrelevant legislation in the form of the Bill of Rights, the Act of Settlement, neither of which have relevance to this current injunction proceedings. The respondent is wrong in law with their assertions and has failed to realise that not only have the majority of the sections of the Acts been repealed, but the Acts were only relevant to the Parliament at the time. For the avoidance of doubt, the Cabinet Briefing Manual 2011 specifically specifies that the Bill of Rights is part of the Constitution of the UK. The speech from Betty Boothroyd, made on the 21st of July 1993, details there has of course been no amendment to the Bill of Rights. The House is entitled to expect that the Bill of Rights will be fully respected by all those appearing before the courts. Now, further to this, a version of the Bill of Rights is presented on the legislation government website, and it basically displays every single grievance, every single section and right granted to the subject as part of the Williamite settlement from the Glorious Revolution is still intact. Okay, Enactment 11 has removed a few words regarding the King or Queen marrying papists. Enactment 12 has been unlawfully removed by the Statute Law Revision Act 1948, which makes non-obstinance void and incurably void. Anything that contradicts the Bill of Rights is void in law. Enactment 11 specifically states that this is the law of the realm forever, and under the coronation oath all successive monarchs agree to rule by the statutes in Parliament agreed. That includes the Bill of Rights. The Bill of Rights contained 12 specific grievances, as is said, 13 articles granted by William II and 13 enactments giving 38 specific items. In a reply to the defence statement, Andrew Richard Perryman has stated the majority of the sections are being repealed, which would amount to 14 of the 26 combined articles and enactments. It's clearly evident there has only been 3 minor amendments and 1 article unlawfully removed. Okay. The Bill of Rights is also known by the long title, an act declaring the rights and liberties of the subjects and settling the succession of the Crown, and as detailed within this notice, protects the religion, rights and liberties of the subject from violation. Such violation has occurred today within this purported building. Bowles versus Bank of England, which is leading case law in regards to the Bill of Rights, was quoted by Parker J, who said, "No practice or custom, however prolonged or however acquiesced in or part of the subject, could be relied on by the Crown as justifying an infringement on the provisions of the unrepealed Bill of Rights. Clearly underpins the relevance of the Bill of Rights today." In a reply to the defence statement, Andrew Richard Perryman has stated the Acts were only relevant to Parliament at that time. It is clearly evident and evidence the Bill of Rights was written for the subjects of the sovereign and to protect the religion, rights and liberties from the arbitrary power of the despot. The arbitrary power that we have seen demonstrated here today within this building. Mr Lateef raised the Bill of Rights in his initial defence statement, and in response to Andrew Richard Perryman knowingly made a false and seditious statement, with a statement of truth perverting the course of justice in doing so by stating the Bill of Rights was only ever relevant to Parliament. Article 45 of Magna Carta 1215 prescribes in law, we will only appoint as justiciaries, constables, sheriffs and other officials only men that know the law of the realm and are minded to keep it well. As an officer of the court, Andrew Richard Perryman is just such official, as referenced in Article 45, Magna Carta 1215, so had full knowledge he was acting dishonestly and with a lack of integrity. The definition of sedition is a conduct or language inciting rebellion against the authority of a state, insurrection or rebellion, a factious commotion in a state, the stirring up of such commotion, incitement of discontent against government, and disturbance of public tranquillity, as by inflammatory speeches or writings or acts or language tending to breach public order, as to stir up sedition, as speech or pamphlet abounding in sedition. Sedition at common law is overt conduct, such as speech and organisation that tends towards rebellion against the established order. Sedition includes subversion of a constitution and incitement of discontent toward or insurrection against established authority, the established authority of our King Charles III. Under Scottish law, sedition is either verbal or real. Verbal is inferred from the uttering of words to create discord between the King and his people. Charles III rightfully ascended to the throne under the laws, not limited to and including an act declaring the rights and liberties of the subject and settling the succession of the crown, that is known as a Bill of Rights, and an act for the further limitation of the crown and better securing the rights and liberties of the subjects, that is also known as the Act of Settlement. Mr Lateef, a loyal subject to Charles III, being denied the constitutional protections of the same laws that rightfully made Charles III by Andrew Richard Perryman, contravene not only the rule of law, due process of law, and the right of Mr Lateef to equality before the law, they cause discord between the King and the King's subjects. Thank you, ladies.
Thank you very much for that. That was Rangi's Mackenzie friend speaking outside the court. I'll just put the court behind me so you can see behind where we've all been. Got a few people with us. He doesn't really want Rangi to go on video to say too much, but we've come here today to give our support. It was an absolute shambles, the court today. It was telling people, the judge was telling people to leave the court, telling people to shut up in the court. We can understand the circumstances, but the usher wouldn't even give his name. He was very, very rude, obnoxious, and very, very forceful. The judge was very loud, raising his voice, and conducted himself in a very, very poor light. And a complaint has been put in about the judge today by Rangi's legal side, and they're going to adjourn this. Well, it's been adjourned until, I believe it's March, when they're going to make a 2-day provision. But what they're going to do is allow them to come in through a side door and be screened from public. So the whole thing is a complete and utter shambles. So guys, stay tuned, and if I can get Rangi to say anything else. Do you want to add anything?
Yes, I do.
I've got somebody who just wants to add something, so let me just get them on camera and let me just go.
So what we've done here today, there's a human rights complaint in. They're causing complete contempt. Firstly, on entry, they make you take off your shoes and socks, which is kind of ruins your dignity. Whilst you're watching the people in the door next door, because they've downloaded an app, they're getting special treatment, which under the statute Monopoly Act 1623, all special privileges removed. So the fact they're making people take off their shoes and belts to go in the court, whilst other people aren't, that's special treatment, and that's a breach of human rights. Then we get up to the court. The clerk refused to give his name, and it's not on public display, so he's in contempt of court. His first name's Aaron. The judge, I got thrown out of court because I asked the judge for his name, because there's no such thing as an anonymous JP, and there's case law on this. He refused it. All he gave was his judge's name, judge whatever it was. So on the question, is that not your legal fiction, sir? He didn't like that, because I just called their bullshit, and he kicked me out. So that's where we're out there. So we've got a human rights complaint in, a contempt of court complaint in, and we'll be pursuing them in their personal capacities.
Thank you very much
No
indeed.
worries.
Thank you for that. Well, there you are, guys. We've spoken to a couple of the guys that back. I'm trying to go back, guys, see if I can get back to where we were. And as you can see, guys, I'm having problems today with this. I don't know why it's playing me up. It would play up when we're live. That's where we've been today, and that's the call. And that is the take on what's happened here today. Really, really like a kangaroo court. Absolute disgraceful behaviour by all, ushers included.
Perryman.
Sorry?
Just have a quick word with my friend.
Of course you can.
Yeah, excellent. Let's keep walking though. No, that's absolutely fine, my friend. I've got a couple of documents there for you. One of them's in relation to your submission and contempt of court by court.
Are you taking me to court?
I believe we shall be.
Okay, good.
We shall be putting in an application to for criminal proceedings against you.
Okay.
Okay. You refusing service?
Yes.
Refusing service.
Yes.
We'll send them to you in a post.
Thank you.